Tonight, calling John O'Keefe. Heated voicemails left by Karen Reed played out in court. What they're revealing about the defendant's state of mind that snowy night 3 years ago.
You didn't seek or receive a search warrant.
No, I did not.
Plus, new details about the searches of the property where O'Keefe was found in the snow. We take a closer look at the investigation from the eyes of a retired police chief. And a nationally renowned legal correspondent joins the conversation. Canton Confidential, the Karen Reed murder trial, starts right now.
44 missed calls, 8 voicemails, and 4 text messages. That's how many times Karen Reed tried to reach John O'Keefe in those early morning hours of January 29th, 2022, just before he was found dead in the snow in Canton. Good evening, everyone. I'm J.C. Monahan.
And I'm Glenn Jones. In addition to those calls, plenty of questions about why Canton police didn't search the inside of the home, outside of which O'Keefe was found. Our Melody Mendez joins us now live from the courthouse with more on today's testimony. Mel.
Well, look, Glenn and JC, Lieutenant Gallagher was back on the stand to start today. It's how we finished yesterday and how we began the day today with some really heated exchanges between Alan Jackson and the retired lieutenant. He really pressed the lieutenant on police work, specifically what wasn't done. Glenn, as you just mentioned, why no responding officers searched Brian Albert's home. And in one of the more heated exchanges, Alan Jackson basically pushed him for an answer, and Lieutenant Gallagher, put simply, stood his ground and said there was no probable cause. Take a look.
I would have to twist circumstances to have the right to search Brian Albert's house. We had no reason, and there's been no reason since.
How about this? How about this? There's a dead guy on the lawn that looked like he potentially could have been in a physical altercation. How about that?
That fiery back and forth as Alan Jackson pressed Lieutenant Gallagher about his police work, going on to ask him what he saw when he used a leaf blower to clear the snow off the lawn at 34 Fairview. Gallagher saying he didn't see a single piece of taillight.
As a matter of fact, you didn't see 46 pieces of taillight material, either clear or bright red plastic, in any part of the area that you searched.
No.
The defense has argued that pieces of taillight found at the scene days after O'Keefe's death were planted by police. Jackson questioned Gallagher about his friendship with ATF agent Brian Higgins, who, with an office in the Canton Police Department, would have access to certain areas. Another bit of police work that Jackson said should have been done but wasn't, getting footage from the security camera of a home across the street, that home belonging to another member of the Canton PD. Gallagher said he didn't ask for the footage from the night in question because he didn't think the camera would have captured that incident, saying he's picked up packages from the home before and the camera only shows the front porch and part of the lawn.
To me, there was no expectation that it had captured anything, so I didn't think it was practical.
The lieutenant was also shown pictures of Karen Reed's SUV in the Canton Police Department's Sallyport. In one photo, an investigator holds open a brown grocery bag with plastic Solo cups inside, holding John O'Keefe's blood collected from the scene.
They were not in an evidence bag, they were in a grocery bag, correct?
Jackson noting it wasn't sealed and its proximity to the SUV, trying to show there could have been cross-contamination.
You will agree that having unsealed and unsecured blood right next to the right rear of the SUV is a recipe for cross-contamination, wouldn't you?
Next up, the Commonwealth recalled State Trooper Nick Guarino to the stand. He's the man who extracted data from Reed and O'Keefe's cell phones.
So at 12:35 a.m., the defendant calls John. That phone call's not answered.
He showed all the attempts by Karen Reed to call John O'Keefe throughout the night, some 52 times, and then the voicemails. One after another, prosecutors played angry voicemails Reed left on his phone.
At 1 in the morning, I'm with your nephew, you pervert.
She left 8 in all, the final one just after 6 a.m., where the phone records the commotion at the scene just after John's body was found, corroborating previous witness testimony of Reed's state at the time. All right, now another interesting note here to point out is that the trooper, using data from Karen Reed's cell phone, was able to establish that she connected back to John O'Keefe's in-home Wi-Fi at 12:36 that morning. JC and Glenn.
Well, there's just an avalanche of the cell phone data in this trial, but I do remember that Wi-Fi detail from the last one. We did hear about that in the last trial, correct?
We did. You're absolutely right, Glenn. And that's because it became increasingly important when it comes down to establishing a timeline here, right? Where did Karen Reed go after leaving 34 Fairview? The fact that she connected to that Wi-Fi at 12:36 a.m. will become increasingly important as we see the defense put out their narrative about what they say happened that night. Guys, back to you.
Melody, thank you. We want to welcome in retired Newton Police Chief John Carmichael. John, thank you for being with us.
Thank you for having me.
Decades of experience, both as an officer and a police chief. So I want to ask you a question that we have heard so many of you ask, which is, why didn't they just go into the house that day? We just heard Paul Gallagher, the former Canton Police lieutenant, say they didn't have probable cause. There was no reason to go to the door. Shouldn't they have tried? Couldn't you at least ask if you could go in and look around? Or they could have tried to get a search warrant and been denied. That's okay, right? Or
Sure.
Is it, to us, should it be more obvious that they didn't have a reason to go in?
They didn't have a reason to go in. If you look at this call, the way that it came in originally, this came in as a medical call where there was an unattended death, and the officers on scene handled the call appropriately up to that point. You know, here in Massachusetts or anywhere in this country, you have an expectation of privacy in your home. And the fact that this person unfortunately passed away at this location does not mean that there's any nexus or link to the home itself as far as probable cause existing that a crime occurred. Or, when you apply for a search warrant, you have to complete an affidavit. You have to swear to that affidavit. And you have to have probable cause established in order to even apply for a search warrant. And in this case, you didn't have that. In order to go into that home, you need to identify the premises that you would want to search, as well as any fruits or instrumentalities of the specific crime that you're looking for. In other words, the specific items.
Why are you there? You have to say, like, why am I going in? I want to search this particular room. Is that right?
That's right. And what you're looking for. And so at that early part of the investigation, there was nothing to indicate that there was a crime that was committed. As far as John O'Keefe himself, never mind the home that he happened to be in the curtilage of.
Well, let's look at another law enforcement detail here. I should declare bias. Solo cups as collecting forensic evidence doesn't seem like it's a good idea to me. And I think some of the jurors who are hearing this for the first time will have that same thought. Did Lieutenant Gallagher do enough to disabuse them of that bias? And I wonder if one of your officers use the same ingenuity, whether you could defend their actions.
Right. That's a very good question. Ideally, using the solo cups was not practical. However, in this specific situation, you have officers, the initial officers on scene there, Lieutenant Gallagher showing up, after the fact, but he had the wherewithal to still perform some investigation. The state police had declined to come out to the call, and he still took it upon himself to at least, process the scene, collect any, so-called evidence, even though we don't know that it's evidence yet. But he realized that there was some trace left behind, i.e. the blood, and he made some attempt to collect that and preserve that evidence in the event something else was found out later, and that's exactly what happened.
As someone who's spent your entire career in local policing, I imagine it has to be very tough to hear the criticism, because there is a lot about the way Canton handled this, and this goes beyond Massachusetts. There are people making comments that go, as broad as the attention on this case. Can you speak to that? I mean, should we take this as a bigger problem than just Canton PD?
No, I don't think so. You can't look at these things in hindsight, right? Those officers were there. It was an awful snowstorm, awful circumstances with what happened, and they did their best, in the elements and in that environment to do what they did. And while not perfect, they still accomplished what they were there for, and that was, first of all, to take care of Mr. O'Keefe medically and everything, and we all know the outcome of that. But then to process the scene, at least somewhat, in the event that something else happened later, and as we know, that is what happened.
As a result of the first trial, there was some discipline handed down to some of the law enforcement that worked across this case. Most of that discipline was at the state police level, not the local police level.
Right.
I wonder if you feel like the right amount of discipline was handed out when you look at the totality of the investigation and what we learned in the first trial, including, of course, Michael Proctor's firing.
Mm-hmm. Well, I think, anytime there's misconduct and it's identified, the agency has to address that immediately. There can't be any delay. Those circumstances need to be looked at right away. I think ultimately, discipline imposed was discipline imposed, and it was just, and it was right for the agency to do that.
Okay.
All right, we're going to talk about one of the dramatic moments that happened in court today was the number of calls and texts that Karen Read made to John O'Keefe in those early morning hours, and those voicemails were played in court today. Take a listen, and we'll talk about it on the other side.
John, I'm here with your kids. Nobody knows what the you want, you pervert. Yes, 1 in the morning, I'm with your niece and nephew. You pervert. You're a pervert. John, I'm going home. I cannot babysit your niece. I need to go home. You are using me right now. Another girl, Kim's sleeping next to me. You're a loser. Yourself.
Our courtroom insider, Sue O'Connell, joins the conversation now. Sue was in the courtroom today, so you heard those voicemails being played. For some of us, some of the shine on this was rubbed off because we heard them before. But for these jurors, we have to expect this is the first time they're hearing this.
Well, they heard some of them earlier in this trial, so it wasn't like brand new to them. And I also want to say they've also already heard Karen Read's voice via the clips that we have seen. The last trial, right, these came at the end of the prosecution's presentation. That was the first time they heard Karen. By now, they have a different viewpoint of Karen because they've heard her, seen her via the clips, and heard these. And I keep saying it on X, this jury is really hard to read, right? So they are sitting, taking notes. The majority of them take notes on a regular basis. So the lights are down, these are on the screen, and then it comes up, and they're all just writing. Now, that doesn't mean they haven't had a reaction to it, but there's a very detached part of this jury that is taking in this as evidence and not having an emotional reaction to it. The last voicemail, the one from the chaos at the scene when they found John's body, every time we see that dash cam video or hear something about that, everyone is impacted by that, because I think we can all relate to how terrible that must have been. And that underscores the terrible feeling and experience of finding a loved one or a friend's body in the snow. But at the same time, the jury is just writing stuff down, and I'll be really interested when all this is said and done to find out how they were actually reacting to it.
You've heard them before, and as you mentioned, the jurors have heard some of those before, but it has to sort of reverberate around such a small, packed courtroom to hear this anger, yelling, and understandable chaos on that morning. I would think.
And as we talked about yesterday, it's not a TV show, it's a courtroom, right? So they're not checking the volume levels when they play it. I think they've gotten to the point where they understand they just can't hit a button and have Karen screaming in one of the voicemails, because then the jurors won't be able to hear it and understand. So they're trying to set it up a little bit more. And being able to introduce the evidence also confines the Commonwealth on how they can't do a setup like, well, here's this and here's that. Trooper Garino was able to do that with these voicemails, doing a sort of timeline, TikTok, via the messages and the missed calls and the text messages. So it gave more of a holistic approach in understanding, I think, for the jurors to see it, rather than just the bits of it that we heard last time. So I'm just interested to hear what they have to say.
Chief, let's pick up on Sue's last point about the timeline here, because the prosecution is saying that these voicemails happened, for the most part, after they say Karen Read hit John O'Keefe. So if she's leaving these voicemails searching for him, doesn't it tell us something subliminally about intent? One of the things they are trying to prove that Karen Read is responsible for.
Well, certainly those phone calls and the text messages are very frantic. You can hear the desperation, obviously, in her voice, and certainly something is wrong there. Dealing with this situation like this hours later, instead of maybe reporting it to the police originally. If you have a loved one and they're missing, never mind 1 or 2 hours during the middle of a snowstorm. We're talking several hours later now, and it still hasn't been reported in. That would be concerning for me.
Yeah. Some could flip it and say she didn't know where he was, and that's part of the reason behind those.
And her friend said he might be on a couch.
Right.
You know, that was the other thing too. So.
All right. Thank you so much for joining us. We will be back right after this break.
Don't miss any of the Karen Reed murder trial. Get the full recap of what happened in court, expert analysis, and what we could see next. This is coverage you won't see anywhere else. Canton Confidential, weeknights at 7 on NBC 10 Boston.
Unfortunately, John O'Keefe was deceased at this time. Once John O'Keefe becomes deceased, it becomes the state police's investigation, the Norfolk County District Attorney CPAC investigation. That's why it is not our investigation. It's up to the investigating agency to make those decisions.
Even something as uninvasive as taking photographs?
Yes.
Okay.
Today, Alan Jackson investigation into John O'Keefe's death. That's more of his cross-examination of now retired Canton Police Lieutenant Paul Gallagher. We're thrilled to be joined tonight by NBC News legal analyst Danny Savalos. We understand he's been monitoring this case very closely.
So, Danny, we're thrilled that you could be with us. We're in week 3 of testimony. There are a lot of trials that are happening across the country, frankly, across the world. Why is this one attracting your attention? Because we've been asking a lot of people what it is that has garnered this kind of effort of eyeballs on the case.
Oh, in a way, this case has everything. But if I were to distill it down to one word, it would be conspiracy. Everybody loves a good conspiracy theory. And the theory here is that, at least according to the defense, that the police in this case were so tight in this small town that they covered up what really happened to John O'Keefe and pinned it on the defendant. Most of the time, the defense puts on no theory at all. This one's not only elaborate, it is fascinating.
So there's been so much attention, as you mentioned, on the police investigation. In some ways, going into this trial, Special Prosecutor Hank Brennan is at a deficit because he has to convince the jury that everything is on the up and up with the police investigation. Let's take a listen to how he's handling that in his direct examination of Lieutenant Gallagher.
What is the natural process for an investigator when you start upon a situation and know nothing about what happened?
In this particular case, we came up with scenarios that possibly could have brought John to that spot. And we were focused on trying to find out and hopefully getting to the hospital. Hopefully the can't fight department in the hospital would save his life and he could tell us how he got to where he was.
So, Danny, what's your opinion of the quality of the police investigation in this case, and how is the prosecution doing in overcoming any hurdles you see there?
The defense has done a good job of raising the specter of a bad police investigation. But let me just give you an example. One of the witnesses testified that he collected evidence using solo cups, like the kind you see at the frat house to hold liquor. And that could have gone terribly for the prosecution. But when you listen to the witness testify about it, he's matter-of-fact about it. He's forthcoming. He says, yeah, that's what I had. And actually, the solo cups worked out great. And I can tell you as a defense attorney, I've had exactly 0 cases in which police collect evidence with solo cups. But the way the witness testified, he may have gotten through. After all, he said, well, that's what I did. And I don't think it was that big a deal. The question is, did the jury see this as a big mistake by the police, or did they see it as the witness testified as no big deal, he used what he had available?
Danny, you know, Hank Brennan, the prosecutor, continues to feature video clips of Karen Reed between witnesses as they take the stand. It happened again today. But what do you think about Reed talking on the record with so many different media outlets that now can be played in front of a jury?
Generally speaking, defense attorneys don't like their clients talking to the media. Now, that view has changed some over the years because, let's be honest, normally the prosecution controls the narrative. They have the press conferences, they put out the press releases, and rarely does the defendant get to combat the facts. But that being said, there's a pretty good test for whether or not a public statement by Karen Reed was a good idea. If the prosecution is using it in their case, you can bet it probably wasn't the best thing for her to say say on air, on tape, to a camera.
This is the prosecution's case right now, so we're dealing with prosecution witnesses. Anyone who has been on the stand this time around in trial number 2 whose testimony really stood out to you?
Yes, and in a way I would say many witnesses' testimony stood out because it's their second time testifying. Of course, Jen McCabe is the one everybody talks about. And the second time around, it seems, at least this is my perception, that these witnesses have tightened up their testimony. Yes, of course, they have inconsistencies. All of us would have inconsistencies testifying one year and then the next year about the same facts. I mean, we probably would have inconsistencies testifying about something that happened last week. But you notice that these witnesses seem a little more prepared. Jen McCabe didn't fight back as much during cross-examination. She seems to get it. And the best way, folks, to fight cross-examination if you're a witness is not to fight with the attorney. It's to just be matter of fact and just answer the question as it's asked. And I think Jen McCabe did a good job at that and did a good job not withering under cross-examination by these very good defense attorneys.
Danny, what about the fact that the defense has taken it upon themselves to do a third-party culprit? They don't have to prove anything. The prosecution has to prove the case, but now they're putting that burden on themselves to convince a jury there could be others involved, not Karen Reed. What did you think of that decision?
So it's interesting. This is a case that maybe the defense, if it was of less notoriety, you might have seen a defense of no defense at all and make the prosecution meet its burden. After all, nobody saw the incident occur. No, there's no eyewitness to O'Keefe getting hit. They might have gone with a theory of some other car came along, or you can't prove that some other car didn't come along and hit him. Instead, they came up with this kind of conspiracy theory. And frankly, I'm not entirely sure their theory is going to be exactly the same as it was at the first trial. We're already getting these kinds of hints that maybe they might go in a slightly different direction, and some of that evidence this time around has been precluded. So to the extent they come up with this alternate theory, I'm really interested to see how much they flesh it out, or if they just kind of give some broad strokes and say, well, that's enough for reasonable doubt. But you're absolutely right. Generally, the defense has to prove nothing, and frequently I rest my cases without calling a single witness and argue in closing that they're the ones who had the burden. They didn't meet their burden. You didn't have to hear anything from us.
NBC News legal analyst Danny Savalos, so great to have you with us tonight. I expect we'll see you again before this trial is over.
Thank you.